Donald Trump is now trapped by his own horrible lawyers and his own contradictory arguments in the various different cases where he's just seeking one thing: delay, delay, delay. But as special counsel Jack Smith has remained patient and consistent, Donald Trump has acted erratic and afraid and scared. So here's what went down, and let me explain to you how this is all related with each other. So Donald Trump just lost a petition to stay a mandate from issuing by the Second Circuit Court of Appeals in the E. Jean Carroll defamation case set for trial in January. This is the other E. Jean Carroll case. Of course, back in May, Donald Trump lost a $5 million judgment. A jury in a federal case, the first case to go to trial by E. Jean Carroll, found that Donald Trump engaged in sexual abuse, which is the same thing as civil rape in a civil case, as well as defamation, and E. Jean Carroll was awarded $5 million. This is the other case that involves Donald Trump's defamatory statements while he was in office, statements Donald Trump made when he was disgracing the White House back in 2019 during press conferences and press statements where Donald Trump first defamed E. Jean Carroll. The reason that the case based on defamatory statements by Donald Trump from 2019 is actually going to trial second versus the case from Donald Trump's defamatory statements from 2022 and the sexual abuse that Donald Trump was found liable, that one went first because there were appeals relating to the 2019 statements made by Donald Trump. And so that worked its way through the courts. Ultimately, as this case got near trial, the other defamation case that's set for trial in January, Donald Trump's not so brilliant lawyers went, "Oh, crap. We never asserted absolute presidential immunity as a defense, and we're asserting that in other cases, so shouldn't we have asserted this here? Donald Trump's statements were made while he was in office in 2019. Why did we not assert it? I don't know. Maybe because you went to 1-800-ALINA HABA as your lawyer, and all you have to do if you want to assert something as an affirmative defense, it's basically check the box. You write on a pleading called an answer, Donald Trump hereby asserts as an affirmative defense absolute presidential immunity. So Trump didn't do that for 3 years. So the district court and the Second Circuit Court of Appeals recently ruled, you snooze, you lose, Donald Trump. You did not assert absolute presidential immunity. So we don't even have to address the issue about whether or not your conduct relating to E. Jean Carroll falls outside the outer perimeter of the doctrine of absolute presidential immunity in civil cases that was recognized in the Nixon v. Fitzgerald case in the early 1980s. And this doctrine of absolute presidential immunity has been recognized in civil cases, although in the Blassingame case recently decided by the D.C. Circuit Court of Appeals, they said that Donald Trump's conduct relating to the January 6th insurrection clearly falls outside the outer perimeter of the absolute presidential immunity doctrine because the conduct involved election and campaigning. That's what the Blassingame D.C. Circuit Court of Appeals decision issued December 1st said. So why is Donald Trump trapped now that the Second Circuit Court of Appeals just ruled that Donald Trump is unable to stay their ruling, affirming what the district court did, where the Second Circuit affirmed that Donald Trump, you snoozed, you lose. Alina Habba, snooze, she loses. You don't get to assert absolute presidential immunity grounds. Now, one of the arguments that Donald Trump made to the Second Circuit Court of Appeals to try to delay the E. Jean Carroll defamation case from going to trial in January because he's so fearful of being hit with a Rudy Giuliani size $150 million or so judgment. Get this. Trump argued, look, Second Circuit Court of Appeals, look what Jack Smith is doing in the Washington, D.C. criminal case against me. Yes, that's right. You heard me right. Donald Trump is citing special counsel Jack Smith about why absolute presidential immunity should be heard by the Supreme Court. Donald Trump's basically saying Jack Smith is authority that I'm relying on. What Donald Trump didn't say to the Second Circuit Court of Appeals, of course, is that Donald Trump went to the United States Supreme Court and said to them, when it comes to special counsel Jack Smith trying to get a direct appeal of the district court's denial of Donald Trump's absolute immunity defense in the criminal case in Washington, D.C., Trump opposed that when Jack Smith sought to get that case directly to the Supreme Court. So while Donald Trump opposed Jack Smith's effort to ask the Supreme Court to hear Donald Trump's appeal directly, Donald Trump was arguing to the Second Circuit, hey, look what Jack Smith is saying to the Supreme Court. If Jack Smith says absolute presidential immunity is important, Second Circuit Court of Appeals, I may actually go to the Supreme Court as well, the same way Jack Smith is doing here. So can you do me this solid, Second Circuit Court of Appeals? You know, I got this E. Jean Carroll case that's now set for trial. The district court is rejecting my affirmative defense of absolute presidential immunity, saying I waive it. You've just rejected that on appeal, saying that me and Alina Habba waived it. I may go to the Supreme Court. Can you give me a 90-day delay, Second Circuit Court of Appeals? Can you delay that E. Jean Carroll trial in January before the Southern District of New York Judge Kaplan? Because look, Jack Smith went to the Supreme Court. I may want to do that. The Second Circuit Court of Appeals, of course, ruled, nope, we are not going to stay our mandate. We are not going to stay the E. Jean Carroll case. Wish you the best of luck, but our order, affirming the district court's order, is what the order is, and we're not slowing the district court proceedings down. You know, good luck at your trial, Donald, is basically what the Second Circuit said. So Donald Trump is now trapped because Donald Trump's move right now, after getting rejected by the Second Circuit Court of Appeals, which is the boss of basically, which supervises the Southern District of New York, what's Donald Trump left with? Yes, you guessed it right. Petitioning the Supreme Court for certiorari on, because trial's happening in January. So what does Donald Trump have to do? He has to petition the Supreme Court of the United States on an emergency basis to now stay or pause the E. Jean Carroll case in January, because Trump has to argue these issues of absolute presidential immunity are so important. Supreme Court, you need to hear this now. Does that sound familiar? It does. That's what special counsel Jack Smith tried to argue that Donald Trump opposed when it came to the criminal case where the district court judge denied Donald Trump's motion to dismiss the indictment where he asserted absolute presidential immunity. And Trump was like, nah, Supreme Court, it's not that much of an emergency. Chill out. We'll see what the D.C. Circuit Court of Appeals says. And then maybe Supreme Court, you could kind of step in. So E. Jean Carroll, in pursuing the case, not only did she get some sense of justice based on the ruling from May, where she was awarded $5 million and Donald Trump was found liable for sexual abuse and defamation, but in pushing forward her case to trial, she got Donald Trump now trapped to slip up, where if Donald Trump argues, Supreme Court, you should hear the issue of absolute presidential immunity now because Donald Trump wants to delay the E. Jean Carroll case because he knows that he's going to get hit with a massive judgment, then special counsel Jack Smith goes, you see, Supreme Court, we told you he thought this was an issue that needs to be heard on an emergency basis. Guess what? So does our appeal, or so does our petition for Donald Trump's appeal to be directly heard by you, the United States Supreme Court. So because Trump is making kind of conflicting arguments, when it came to Jack Smith before, telling the Supreme Court, whoa, you don't need to hear this. And then citing to the Second Circuit Court of Appeals and E. Jean Carroll, hey, Second Circuit, Jack Smith thinks this is important. You should think it's important too. Please delay the case. Please delay the trial in the E. Jean Carroll matter. That, folks, is why Donald Trump is trapped. And here's an important point to contemplate as well about the Second Circuit denying Donald Trump's attempt to stay the mandate there. When the D.C. Circuit Court of Appeals, right, there's different courts of appeals throughout the country. So in New York, Second Circuit supervises New York. When it comes to the D.C. District Court, the trial court, they're supervised by the D.C. Circuit Court of Appeals. So inevitably, remember, oral argument is January 9th before the D.C. Circuit Court of Appeals on Donald Trump's appeal on the issue of absolute presidential immunity, where Donald Trump alleges all of the things that special counsel Jack Smith is accusing me of constitutes official acts of the presidency, and therefore I am absolutely immune from any criminal prosecutions because they constitute official acts. So when the D.C. Circuit Court of Appeals rejects that ridiculous argument, what is Donald Trump going to do with the D.C. Circuit Court of Appeals? He's now going to have to do what he did with the Second Circuit Court of Appeals, which the Second Circuit Court of Appeals rejected. And the D.C. Circuit Court of Appeals, Trump's going to ask, can you stay the mandate? I don't want to go to trial. The same way in New York, he said, I don't want to go to the civil trial before the Southern District of New York. He's going to go to the D.C. Circuit Court of Appeals saying, look, you've ruled against me. You've affirmed what Judge Tanya Chutkan is going to do. Can you stay your mandate? And I think the D.C. Circuit Court of Appeals is going to go, just like the Second Circuit did, no, we're not going to stay the mandate. So then what's going to happen? Then Donald Trump's going to have to, he's stuck again. He's trapped again. Is he going to go to the Supreme Court then and say, well, Supreme Court, now I want you to hear it. Now this is an emergency issue. Well, Donald, you just argued earlier to the Supreme Court when Jack Smith wanted to hear it. You argued that this isn't an emergency. So what if the Supreme Court now says, look, Donald Trump, you argued this wasn't an emergency when special counsel Jack Smith wants us to hear it. So why don't we just have you go through the trial before the district court? Let's see what the outcome is. And then you can bring the case to us, the Supreme Court. Once you see what the outcome is, if you're convicted, then you can bring it up through the appeals process. But you even said it wasn't that much of an emergency. So go and have your criminal trial in Washington, D.C. Now, there's another layer to this, and we're really geeking out here when it comes to the law. So I hope you're enjoying this. Let's go south a little bit to the 11th Circuit Court of Appeals, because they did something that I'm not sure if I've talked about it here, but it's really gone unnoticed. So, of course, we now know the 11th Circuit rejected Mark Meadows' appeal on the issue of federal officer removal. Remember, Meadows was saying, I'm an officer, I was acting under color of my authority, and I have legitimate federal defenses. And therefore, the Georgia state criminal RICO case before the Fulton County Superior Court should be removed to federal court. The federal judge rejected that, saying you're not acting under the color of authority of being an officer. You were engaged in election interference. And Article 2 has nothing to do with elections and campaigning. Those are states' rights issues. The 11th Circuit Court of Appeals, the boss of the Georgia federal, the federal court in Georgia, the district court in Georgia, they go to the 11th Circuit. So you get it right now, right? New York, Second Circuit, D.C. District Court, D.C. Circuit. You go south to Georgia. That's the 11th Circuit Court of Appeals, which also supervises Florida. And the 11th Circuit said former federal officers cannot remove, only current federal officers can remove, and you were not acting under the color of your authority as a federal officer, because we agree with what the district court said. You were engaged in Hatch Act violations, campaigning, interfering with the results of free and fair elections, has nothing to do with Article 2 authority. So then they take that ruling, and then Jeff Clark, Jeff Clark, the DOJ flunky who tried to become the attorney general for Donald Trump, the acting attorney general, to send letters to the various states telling them to overthrow the results of the election. He was, of course, criminally charged in Fulton County, Georgia, in Fani Willis's RICO indictment. He tried to remove it to federal court. The federal judge laughed him out there. Jeff Clark then brought an appeal to the 11th Circuit Court of Appeals and then asked the 11th Circuit to stay all of the proceedings pending the appeal, stay what the district court's doing and stay what the state court's doing. And the 11th Circuit, which is has a reputation of a right-wing court. In the Meadows case, you had 2 Democratic appointees, but you had Judge Pryor, who is a very right-wing conservative judge. On the panel, when it comes to Jeff Clark, you had 3 judges. These are 3-judge panels. 2 Trump appointees on that panel and 1 Democratic appointee, but 2 Trump appointees. And this is what's so fascinating. They said, Jeff Clark, look at what we just did in the Meadows case. You have no chance of success on the merits because we just laughed Mark Meadows out of our court, former federal officer and not acting under color of authority. But also, you can't stay these proceedings because even though you cite the Coinbase case, which was decided by the Supreme Court in June of 2023, the Coinbase case talks about staying district court proceedings where the issue is arbitrability and arbitrations. The Coinbase case was an issue where arbitrability was denied. The issue of an arbitration clause was appealed, and the Supreme Court said, stay district court proceedings, stay the proceedings while there's an appeal on the issue of arbitrability. And the 11th Circuit said to Jeff Clark, Coinbase has nothing to do with your removal here on federal officer removal or your appeal here. Coinbase equals arbitration, and that's it. Why that is so fascinating to me is because one of the grounds that federal judge Tanya Chutkan in the criminal case involving Donald Trump, one of the reasons why she ultimately stayed the proceedings before her was based on Coinbase. The Supreme Court, June 2023 Coinbase decision. And she basically said, you take Coinbase, you take this other doctrine called Griggs, which involves stays kind of pending appeals, and applying Coinbase, she stayed the proceedings there. I think the 11th Circuit was sending a message to Judge Tanya Chutkan as well as to the D.C. Circuit saying, you do not, Coinbase is about arbitration. Coinbase is not about Donald Trump, even though what the 11th Circuit was dealing with, the Meadows issues, which has nothing to do with absolute presidential immunity, but acting under the color of authority of being an officer of the executive branch, and then the absolute presidential immunity doctrine. There's some intersection there. I think the 11th Circuit's trying to send a message to the D.C. Circuit Court of Appeals and to the Supreme Court that Coinbase is arbitration. Do not slow down these cases against January 6th insurrectionists like Donald Trump. Do not slow them down. So you see how the various court cases all meld, how you've got the Second Circuit in an E. Jean Carroll rejecting absolute presidential immunity on the issue of waiver, traps Donald Trump in what he may be trying to now argue after the D.C. Circuit Court of Appeals rules against him, which I am so confident is going to happen. And now how the 11th Circuit Court of Appeals in the Meadows and Clark case are signaling back to the D.C. Circuit Court of Appeals and to the Supreme Court, do not slow these cases down. Go. We need justice. And they're not using those exact words, but if you see the sophistication of this, it's how all these courts are talking with each other. So, evolved analysis there. We really got into the weeds of these various cases, but for many reasons, E. Jean Carroll, a total hero for pressing Trump on these issues. Trump's zero coordination between his lawyers traps him in D.C. Circuit with what he's going to try to do to cause delay there. And I think Jack Smith is paying close attention to that as well. Anyway, Hit subscribe. We're on our way to 2 million subscribers thanks to your support, and check us out at patreon.com/MeidasTouch.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.